What is this AMU judgment that everyone is talking about? Let me explain. Hi, I'm Anmol and welcome to this segment of Live Law, where we will dig deep into the issue of Aligarh Muslim University's plea for a minority status and the Supreme Court's ruling in this regard. Simply put, the question before the court was whether the AMU or Aligarh Muslim University is a minority institution or not. Now, what is meant by a minority in a general sense? Supposing you are a Tamil-speaking person in Delhi, you would be a minority in Delhi. Conversely, if there is a Hindi-speaking person in Tamil Nadu, he will be a minority in that state. The same applies to religion. If you are a Hindu in Nagaland, you are a minority because Nagaland is a Christian-dominated state. And if you are a Christian in UP, you are a minority in that state, which is Hindu-dominated. We also know that there are many minority educational institutions like the St. Stephen's College, the Khalsa College, and several other educational institutions by the linguistic and religious minorities. We also have a special act, the National Commission for Minority Educational Institutions Act of 2004, which has been enacted to safeguard the educational rights of minorities enshrined under Article 30 of the Indian Constitution. So if you want to get the minority status for an educational institution, you would just need to make an application before the competent authority recognized by the state. The authority would then do a thorough scrutiny of the application and grant or reject to grant a no objection certificate. Once such a certificate is granted, the applicant can then begin the process of establishing a minority education institution. Then why can't this status not be granted to AMU? What is the issue? And what is this minority status? First, let's understand the minority protection given under our Constitution. Article 29 grants special rights to the religious and linguistic minorities to conserve their culture, language, and script. Now, Article 30, subclause 1 says that all religious or linguistic minorities would have the right to establish and administer educational institutions of their choice. So that would mean that any minority community, like for instance a Christian group, would have a constitutional right to open and run a convent school in any part of India. Such a school would then be recognized as a minority institution. Under these constitutional guarantees, there cannot be much interference from the government. The government can say, look, you are a minority and we will not give you permission to start an educational institution. This protection is given by the Constitution because democracy is complete only when the minority is protected from the majority rule. Now coming to the AMU issue before the Supreme Court. Before proceeding, we should know a bit of history of AMU. AMU's journey, also known as the Aligarh movement, can be segregated into three phases. First, from 1870 to 1877, the idea of a university for the Muslim community started to take shape under the leadership of Sir Syed Ahmad Khan, and this led to the establishment of the Mohammedan Anglo-Oriental College. The second phase was between 1877 and 1910. There was a big push to turn this college into a full-fledged university. Third phase, finally, from 1910 to 1920, the founders succeeded in transforming the Oriental College into now what we know as the AMU. Notably, when the AMU Act of 1920 came into picture, there were two factions within the Aligarh movement. One was known as the Loyalists, led by Sir Syed Khan, which ceded to the British terms for the constitution of the AMU Act, and the other was a faction led by Maulana Mahmud Hassan and Muhammad Ali Johar, amongst others, which refused to agree to the British terms for the incorporation of the university and went on to establish Delhi's Jamia Millia Islamia. Jamia received a deemed university status only in 1962 under the UGC Act of 1956. Now with this background, let us understand further. You have seen that AMU is a university formed through a statute. The minority status of AMU was first discussed in 1967 in a case before Supreme Court known as Aziz Basha versus Union of India. Let's see what Basha has to say. The Supreme Court of India in 1967 was hearing a case in context of certain amendments made in 1951 and 1965 to the AMU Act. It was in this case that the court first held that AMU was a non-minority institution. The bench of the then CGI K.N. Vanchu and Justices R.S. Bachawat, V. Ramaswamy, G.K. Mittal and K.S. Hegre took into account the historical antecedents of the formation of the university and held that while the founder of AMU was a Muslim leader, it cannot be said that AMU was established and administered by a minority under Article 30. The court reasoned that the university was established under a pre-constitutional statute and was an establishment by a statute and not by a minority community. Later, in 1981, an amendment was made to the AMU Act. The effect of the amendment was diluting the Basha judgment and re-establishing that AMU is a minority education institution. Another important milestone in the history of AMU is regarding the challenge to the 50% reservation to the Muslim students. This policy involved allocating 50% of the postgraduate course seats originally designated for the qualified MBBS doctors by the university. Before a single judge bench, the university justified the reservation and argued that the 1981 amendments altered the reasoning of the Basha judgment and that the university could now be treated as a minority institution. However, the single bench held that the university does not qualify as a minority institution. The university then appealed before a division bench against this said order. The division bench said that though the university is founded by a minority, it was not administered or claimed to be administered by a minority community as per Article 29 and 30. So it is against this decision of the division bench that the AMU approached the Supreme Court. The matter was heard by 3 judges bench of the Supreme Court. The bench of 3 judges headed by the then CGI Ranjan Gogoi doubted the Allahabad High Court judgment and held that it should be heard by a 7-judge constitution bench. But before this 2019 reference to the 7 judges, way back in 1981, the Basha judgment of 1967 was also doubted by the Supreme Court while considering a case called Anjuman-e-Rahmania versus District Inspector of Schools that also referred the matter to a 7-judge constitution bench. That's how this matter reached before the 7-judge constitution bench presided by the former Chief Justice of India, Justice D.Y. Chandrachud. The issue before the bench was, and I quote, "What are the indicia for treating an educational institution as a minority educational institution? Would an institution be regarded as a minority educational institution because it was established by persons belonging to a religious or linguistic minority? Or it's being administered by persons belonging to a religious or linguistic minority?" To simplify, the core issue is that what would be the parameters for deciding whether an educational institution like the AMU can get a minority status under Article 30. In a way, the actual question before the bench is whether establishing and administering are twin conditions for a minority community to fulfill when it comes to claiming a minority status for an educational institution. The Supreme Court, after hearing the arguments of all the lawyers involved in the case, had finally delivered the judgment on November 8. It was not a unanimous decision of the 7 judges. In the bench of 7 judges, 4 judges, CGI D.Y. Chandrachud, Justice Sanjeev Khanna, Justice J.B. Pardiwala and Justice Manoj Mishra have given a majority ruling authored by the CGI. Justice Suryakant gave a partially dissenting opinion, while a complete dissent was seen from Justice Dipankar Datta and Justice S.C. Sharma. To answer the reference issue, the court considered 4 main aspects. First aspect: what is the test laid down under Article 30, Subclause 1 for being a minority institution? The bench, in its differing opinions, has interpreted the expression establish and administer and whether the fulfillment of both requirements is necessary and also the extent to which such a fulfillment is required. The majority opinion, authored by the former Chief Justice of India, Justice D.Y. Chandrachud, has given a rather flexible interpretation of the extent to which the requirement of administration needs to be fulfilled. The other 3 opinions by Justice Suryakant, Justice Datta and Justice Sharma have taken a narrow and strict understanding of the requirement of administration by a minority community under Article 30. Let's dissect the difference. The majority opinion held that while a minority community has to show that the institution was both established and administered by it, it was not necessary to prove that the members of the minority were at the helm of the day-to-day administrative affairs of the institution. The court saw the right to administer as a consequence of the right to establish by a minority community and not the other way around. Thus, it took the view that the process of establishment was followed by the freedom of the minority community to run the institution as per its visions and values, and such an autonomy or freedom to administer includes the freedom to choose who runs the day-to-day affairs as well. This means that the responsibility to run the day-to-day affairs of a minority institution may not compulsorily be limited only to the members of the community. I would like to quote what the majority held in this regard. The test is whether the administrative setup of the educational institution affirms the minority character of the institution. If the administrative structure of the educational institution does not reflect its minority character, or when it does not elucidate that the educational institution was established to protect and promote the interests of the minority, it may be reasonably inferred that the purpose was not to establish an educational institution for the benefit of the minority community. The court observed, and I quote, "We have clarified that it is not necessary to prove that administration vests with the minority to prove that it is a minority educational institution, because the very purpose of Article 30, Subclause 1 is to grant special rights on administration as a consequence of establishment. To do otherwise would amount to converting the consequence to a precondition." The majority also discussed the extent to which certain factors would fulfill the test of establishment by the minority community. These are A. The genesis, history, founding intention, or the brain behind the establishment of the educational institution. These things should reflect the creation of the institution by the members or the groups from that minority for the predominant benefit of the minority community. And such can be found from preliminary sources like the letters of communication and memorandums. B. The nature of steps taken to establish, including the source of obtaining the land, the funds raised, or donations received, and other assets of the institution to show that the minority community's efforts in establishing the institution were very much there. C. It was also clarified that in case the land or funds at the time of establishment were granted by the state, a holistic understanding has to be taken of the circumstances that surrounded that time, and that such a state grant will not automatically lead to striping off the minority character. D. Display of religious symbols or existence of place of worship were not necessary indicators of the minority character, as the institution could be maintained out of state funds and barred from religious instructions, or could simply be giving secular education to the members of the minority community. The majority also held that an educational institution established in a pre-constitutional era would not be excluded from getting the benefit of minority status under Article 30. Justice Suryakant, in his separate opinion, stressed that the establishment of a minority institution cannot be determined based on just one specific factor of its founding moments, but through a larger appreciation of the complete timeline from the beginning, and includes an examination of several factors, like who is responsible for the genesis of the idea, the accumulation of funds, the framing of the charter documents, etc. And in such acts, the minority's presence should be decisive. On the interpretation of the extent of administration, Justice Suryakant held that the core part of administration should remain in control of the minority community. Simply put, his opinion states that the minority community should be having a decisive say in the administrative affairs. Justice Suryakant laid down 11 indicators which may suggest when an institution cannot be considered under a minority's administration. The list of 11 indicators highlights that wherever the core decision-making relating to the management, recruitment of employees, fee structure, medium of instruction, governing bodies, deployment of assets, and other things is taken by outside forces or the state, it cannot be said that the test of administration under Article 30, Subclause 1 is fulfilled. In his opinion, he wrote, if the long-term administrative factors in the day-to-day sundry decisions do not lie with the community, it would mean that the institution is being administered by an outside authority and not by the minority community. While Justice Dipankar Datta and Justice S.C. Sharma in their dissents have categorically held that it is the minority community which should have a main and predominant role, almost to the point of exclusion of all other forces in two things. One, intangibly bringing about the entirety of the institution into existence, and two, in the actual functional, executive, policy administration and decision making. It also held that the purpose of the institution must be to predominantly serve the interests of the minority community, irrespective of the form of education provided. Notably, Justice Sharma, in his opinion, also said that the minority institution must also give the option of secular education. He further stated, and I quote, the crux of Article 30 is to prevent any preferential treatment for minorities and thus give equal treatment for all. To assume that minorities of the country require a safe haven to pursue education is incorrect. The minorities of the country have not just joined the mainstream but comprise an important facet of the mainstream itself. The institutions of national character of the country always serve the interests of the minorities and are diverse centers of learning. Now coming to the second aspect of this judgment. Was the decision of the Supreme Court taken in Aziz Basha correct? The 1967 decision of the court in Aziz Basha was the first case dealing with AMU's minority status. The majority opinion presently has expressly overruled the decision in Aziz Basha to the extent where it held that an institution incorporated by a statute cannot claim to be a minority institution. While Justice Suryakant agrees with the majority, he has only suggested the need to modify or clarify the court's observation to the said extent. He noted, and I quote, the legislative intent behind the establishment of a university or an institution will have a significant role in determining the status of such an institution which is created through a statute. But Justice Dipankar Datta and Justice Sharma in their dissenting opinions have upheld the decision in Basha on the reasoning that it has become a settled position of law for more than half a century and that it would not be worthwhile to now interfere with the same. We now come to the third aspect of this judgment. Does AMU qualify as a minority institution under Article 30? The majority of the judges on the bench have refused to answer if AMU in the present case could be granted a minority status. The CJI expressly stated that the issue whether the Aligarh Muslim University is a minority institution as per Article 30 of the Constitution is now left to be decided by a regular bench based on the majority view. So in a way, while the court answered the reference question on how Article 30 is to be interpreted, it has refused to presently go into the factual merits of the AMU controversy. It has clarified that now a regular bench would decide on the factual and legal merits of AMU's plea for a minority status. However, Justice Datta was the only judge on the bench who declared that the AMU is not a minority institution. Justice Datta concluded so by opining, and I quote, I find myself being drawn to the irresistible conclusion that AMU has not been administered by a minority community at any point in time. The Act places the ultimate control of the university with the central government, and the central government and its predecessors have been administering AMU since 1920. We now reach the last important question which the court discussed, which was, would an educational institution, upon being declared as an institution of national importance, forego its minority character and status? The majority opinion held that declaring an institution to be of national importance would not amount to eliminating its minority character. The CJI, in his opinion, explained that the parliamentary powers to declare an institution to be of national importance cannot take away and be given priority over the constitutional rights granted under Article 30. So, an institution can have both the national and minority status at the same time. The dissenting opinions have, on the contrary, held that an educational institution like the AMU, which is an institution of national importance, cannot be given a minority status, as that would go against the very national and secular character of the institution. The dissenting judges stressed that the main intent for declaring the AMU and other such universities under Entry 63 List 1 was to recognize their national significance and put them under the direct control of the central government. But with the grant of the minority status, the union would no longer be able to oversee the key administrative and managerial decisions. The court also ruled on the validity of the 1981 Anjuman-e-Rahmaniya reference, which had questioned the Basha judgment's validity and referred it to a 7-judge bench. While the majority opinion upheld this reference, Justice Suryakant, Justice Datta and Justice Sharma considered the reference to be incorrect. The dissenting judges were of the opinion that a division bench could not have made such a reference in absence of the then Chief Justice of India as part of the said division bench. This, in their opinion, violated judicial propriety and discipline. The division bench should have followed the law laid down in Aziz Basha, which was given by a 5-judge constitutional bench, which was larger in strength of the referring bench. And that was the AMU controversy in a nutshell. Thank you for watching.